Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
The U.S. Supreme Court decides not to fast-track the health care case, but it's on a fast track anyway. I'll be arguing it soon before the Court of Appeals. Hi, I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Shawn Akers, the dean of Helms School of Government at Liberty University. You know, Shawn, the newspapers recently had an article regarding U.S. top court rejects quick health care law ruling. That was from the one of the newspapers that I'm reading from right now, and it was involving the United States Supreme Court considering the request from the state of Virginia, the Commonwealth of Virginia, to take the case on the health care and bypass the Court of Appeals. Now, I said that that's what was going to happen in the beginning because at the end of the day, if they were to take it versus where it is right now in the system, it's only about a 5 to 6 month difference anyway in ruling. So it's already on a fast track.
It's already on a fast track, and to do that right now, frankly, would just open the doors for some other criticisms about the nature of the court and the reasons they would fast track this particular case. I think it was probably a wise decision to let it play out over the next few months.
I do too. You know, the election cases of 2000, obviously those need to be fast-tracked because you had a clock ticking with regards to the election and the certification of the election. But in this particular case, the health care law is going into effect as we speak. Its ultimate implementation is still into the future, but it's going into effect as we speak. But we already have a fast track in process. I'm arguing the health care case on May 10 in Richmond, Virginia, at the Court of Appeals. And Ken Cuccinelli, who also his office is representing the Commonwealth of Virginia as the Attorney General, is arguing also the health care case then as well. So he has his case, we have our case. Ours is Liberty University versus Geithner. And they'll be argued the exact same day before a Court of Appeals that actually decides its cases fairly quickly. And so that means that we'll have a decision sometime by the end of the summer, early fall, and this case will be up to the United States Supreme Court probably by the end of the year or in January of 2012 with a decision no later than June of 2012. Had the Supreme Court stepped in, the earliest it possibly could have made a decision would have probably been the late fall, like December, November of 2011, or the early part of 2012. So really you're only talking about a few months difference. So at any rate, I think it shows no indication from the Supreme Court where they're heading on this case. I think it was the right thing for the Supreme Court to do. Let this go through the Court of Appeals. It's going to get there in a few months anyway.
No, but I don't have any criticism at all, though, of Ken Cuccinelli. In fact, just the opposite, actually asking for the expedited, because what he's doing, I think, I haven't been inside his head, but if I were him, this would be an excellent way to ask for an extraordinary thing that you know is likely to be denied because it's already on a fast track. You know that it's not likely to play out and you to get this fast track. But what it does is say we are very, very serious about this case. We're going to push this case very, very hard. But now what we look up in Virginia, we have you arguing, as you said, on the same day as Ken Cuccinelli. In the long run, I think this works out better for us, and it gives other states, the states that are adding on to this dog pile against this unconstitutional atrocity are extreme. It's something that you're going to wind up having a good collection of attorneys general and interested parties who are all attacking this thing at the same time, and it'll reveal, I think, Matt, just how far out of the mainstream thought this piece of legislation is.
It really is. We have this case on May the 10th, and we're the first case to be argued in the country at the Court of Appeals level. Then there's other court of appeals, like 2 different courts of appeals, about a month to 5 weeks after ours. One in the 6th Circuit out of Michigan, one in the 11th Circuit out of Florida, and some of those attorneys general that that were part of that case. But ours is the first one in the entire nation. And then besides that, the Fourth Circuit Court of Appeals, where we are, that covers Virginia and some of those other surrounding states, has always been known as a court of appeals that makes its decisions fast. They don't spend a lot of wasted time. You don't have to wait a long time for their opinions. So we're being argued 4 to 5 weeks earlier than anyone else. At a court of appeals, that's one of the fastest to make decisions in the country. So that means we will have a decision very quickly later this year. And then from that decision, no matter who wins or loses, I think the Supreme Court will take the case. Obviously, if the court strikes down the statute, it's an automatic trip to the Supreme Court because that is a mandatory review when a court strikes down a federal statute. It's automatic to have it reviewed at the United States Supreme Court. If the Court of Appeals upholds the statute as constitutional, I think the court will still review it, even though there's no conflicts yet in the circuit out there on the same issue. Why? Because in order to do it, in order to uphold this law, they'd have to be blazing brand new territory and expanding the Constitution far beyond what the founders envisioned and really expanding the role and impact and the control of government. And I think the Supreme Court would take that case because of its significant national importance.
You know, I think you're exactly right. For our listeners, a lot of times with the Supreme Court, there are several factors that the court looks at before accepting a case for review, and one of them is whether there's a conflict among the states, whether two states came to completely different conclusions on the same issue of law. But it's not a prerequisite. You don't have to have that. You can have just a case that's that important. And in this particular case, I think you're right. The writing's on the wall that it would require such an expansion of the reading of the Constitution to allow this law to stand. It's just too important. And I tell you, they probably the whole world probably sits back and looks and says, boy, something's going on in Virginia, because you have an attorney general that pushed it that hard. And as you just pointed out, Liberty Counsel is first to bat on this thing. It literally, Matt, you couldn't have wasted very much time at all between I don't think the ink could have been dry on this before Liberty Counsel was taking action if you're the first in the queue.
Well, we filed this case on March 23, 2010, which was the exact day that this law was signed by President Obama into law. This bill was signed into law. So we filed the lawsuit on the same day, and there was 2 other lawsuits too. It was Ken Cuccinelli's representing the Commonwealth of Virginia, and then also the one in Florida with then Bill McCollum as the Attorney General. Ours is the first private lawsuit, but it was also on the very first day. But then ours got fast-tracked as we were moving through the system, and it went right to the Court of Appeals. And ours was the very first case that was set for oral argument out of any other case in the country at the Court of Appeals. So we're in a good position to get a quick ruling on this. And you never can tell where the courts will ultimately go, because judges are judges and they don't always follow the explicit rule of law. But I say that if the court would uphold this, we're in a whole new era. This really changes the constitutional makeup, because this would allow for the very first time the federal government to tell every individual in America to participate in buying something, to force them into a market they don't want to be a part of, to buy a particular product that the government specifically chooses the details of that product. And it would be the first time in America that we would allow the federal government to force an employer, a private employer, to actually contract with a third party and buy a specific product from that third party. So you think of the impact of that, the implications, and it's staggering. You know,
Matt, one of my favorite writers, and you and I discuss him occasionally, is Frederick Bastiat, and he gives a real simple way to determine whether a government is doing something legitimate or illegitimate. And what he says is that what you really have to do is just ask yourself whether you as a person would be arrested and prosecuted for doing something that the government is now doing and getting away with. In other words, if you were to take someone's wallet and give it to someone else, you would be prosecuted for theft. And in this particular case, it's hard to imagine forcing a fellow citizen, another individual, to buy something that they don't want, or forcing them to buy under conditions that they didn't choose. But that's precisely and exactly what the federal government is attempting to do here. And you're right, the departure from normal constitutional procedure and content is staggering.
It really is. So this would be a different day, a different America if the court ever went this far. give us a call at Liberty Counsel and learn more about this case, to partner with Liberty Counsel financially to help us as we move forward in this case, as we're doing all of this pro bono, of course. You can go to Liberty Counsel's website and make an online credit card contribution, or you can send a contribution to our address right there at the website, lc.org, or call us at 1-800-671-1776. You may have other means that God has blessed you with, and you can bless Liberty Counsel with to help defend life, liberty, and family. This is an important case. It'll be a landmark decision, and we'll be right there involved in it, and we're not able to do that without your prayers and financial support. Also, when you go to the Liberty Counsel website, ask for the book Original Intent by David Barton.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.